Thank you for inviting me over for this very interesting webinar that we are having today under the aegis of your organization, PLE. Uh, Now, as all of us know, the Supreme Court has delivered a landmark judgment so far as Hindu personal law is concerned. But before we go to that judgment, it is absolutely necessary for all of us to understand how all this came about. So for that, we have to travel back to quite a number of years. Now, as all of us know that the Hindu law was actually codified in 1937 and then later on in 1955. But what was the position before that? Before the codification, what we had was something that is known as Old Hindu law or Shastric Hindu law, as they say. And why the word Shastric? Because it comes from our Shastras, that is why. Now, so far as rights of women under Shastric law are concerned, what were the rights? Or I would say, what was the right? Because there was one right. A woman had the right to be maintained from the property and the income of the family. No other rights were there. That was the only right that a woman had. Uh, and why was this? Because earlier there was this concept only of joint family holdings or joint family property. Hindu families normally would not have people branching off in or branching out into various businesses or professions of their own. Everything that was done by the family. All the proceedings and the profits were shared, and the family, including women, were of course maintained from that. So that was the extent of women's rights so far as a coparcenary was concerned. And this period that I'm talking to you about is it goes back to more than 100 years or even more than that, ever since people started doing business, I would say. So it's been quite a long time since this has been there. Now, one of the first attempts that was made to give Hindu women some right was by the Hindu Women's Right to Property Act in 1937. What right was given here? The woman, that is the widow, had the right to get her husband's property. She also had a right to dispose of that property. But again, there was a limitation here. She was given only limited rights. She could dispose of the property only under circumstances, certain circumstances which would probably exist, and that which is known in Hindu law as legal necessity. If she had a legal necessity, she could dispose of the property. But if it was later found on a challenge that there was no legal necessity existing, then such an alienation or disposal of the property would be set aside, and the property would revert to the family once again to be distributed later on, of course. So, only a limited right of disposal was given under the 1937 enactment. That, of course, came to an end uh, because a very, very momentous change took place in 1955. Along with the other Hindu acts, the Hindu Succession Act 1955 came into force. Now, with other things that were dealt with under that act, one very important change, which actually went quite a bit away from the old or the Shastric Hindu law, was that Hindu women were given certain rights, inalienable rights, you can say, absolute rights were given. Now, what did that section do? That section said that if a male Hindu died and if he had left behind a female, then that female, namely the wife or maybe the daughter, could uh, claim the property that had been left behind by him or claim her share from the property, which would actually result into what is known in law as a deemed partition. Not an actual partition, but a deemed partition. And why was this done? this was actually done in order that upon the death of the husband, say the widow's right or the woman's right could be locked in. So suppose she was entitled to say one-fifth of the husband's estate, then that one-fifth would be locked in for her. Thereafter, of course, it was up to her as to whether she wanted to seek a partition and go away from the family, or whether she wanted to still remain as a part of the family. Now, here I must digress a bit. Who can ask for a partition is very important. See, only a co-parcener can ask for a partition. That's a very well-known concept under Hindu law. And to be a co-parcener, you have to be born into the family. Now, since the wife is not born into the family, she comes from another coparcenary, say her father's coparcenary. So how could she claim a right? How could she claim a partition? That right was actually given to her under the Partition Act, saying that she could claim a partition upon the husband's death. Now, please mark the words claim. As I said, she could choose not to partition the property. She could choose to partition the property and go away. Now, this section actually came up for interpretation before various courts, trial courts, high courts, went right up to the Supreme Court. There are many judgments on the issue, but the landmark judgment, so far as the old Section 6 is concerned, is State of Maharashtra versus Narayan Rao. What did that judgment say? That judgment said, and I quote, that there is no doubt that there is a right of a female heir in the interest by her in the family property, which gets fixed on the date of death of the male member. But the Supreme Court said this, but she cannot be treated as having ceased to be a member of the family without her volition. Meaning thereby that without her taking any action. Otherwise, the Supreme Court said it would lead to strange results which were not contemplated by the legislature. Now, this judgment was also further analyzed time and again, and consistently the Supreme Court said and upheld the view that yes, it is up to the woman whether she wants to remain in the family or not. What does she want to do? What does she want to effect a partition and go away? That must depend upon her. Therefore, the voluntary right of the widow was recognized by that judgment. Now, many years later, probably in 2016, there was a judgment, which is the judgment of the Supreme Court in Uttam versus Saubhag Singh. Now, this judgment was important in itself. Why? Because this judgment completely, according to me, it undid everything that was explained absolutely properly by the Supreme Court itself in state of Maharashtra versus Narayan Rao. I don't repeat what was said because I've already told you about this. But in Uttam versus Subhag Singh, what did the Supreme Court say and what did it do? It said that in order to determine the share of the male co-parcener who is governed by Section 6 proviso, a partition is affected. Now mark the words, a partition is affected by operation of law immediately before his death. And in this partition, all co-parceners and the male Hindu widow get a share of the family property. But the Supreme Court did not stop there at all. What did the court do? The court said, therefore, that a partition of the property would be affected. The whole property would be distributed amongst the co-parceners, and the family would cease to be a joint family in all respects. So this was actually the new interpretation that was given by the Supreme Court then. Now, as the author of Mullah's Hindu Law, I soundly criticized that judgment in maybe about 3.5 pages, pointing out as to why the Supreme Court was wrong. Uh, I also pointed out that this could never have been done because what happens in a co-parcenary? One, first of all, you have to be born into the co-parcenary to be a co-parcener. If you want to go out, there is always a partition that can be affected. So far as death of a co-parcener is concerned, what happens is then the property would go by survivorship to the other co-parceners. So there would be a reworking of shares only. But it is nowhere said even under Shastric law, nor did the old section 6 also say this, that and clearly say this, I would say, that there would actually be a partition. So I believed that the Supreme Court was absolutely wrong so far as Uttam versus Sobhak Singh is concerned. I would go so far as saying that if you look at this, if you make a comparison, say between the Mitakshar and the Dayabhag system of law. Now, Dayabhag, as all of you know, is prevalent in West Bengal. Uh, what happens in a Dayabhag system? The father is the current holder of the property. The sons do not have any right up to the time that the father is alive. So the father can do anything with the property. Sons have no rights, but their rights open up the moment the father dies. Probably, I say in this forum, as I have said in another forum also earlier, I don't know, erroneously probably, the Supreme Court probably had elements of Dayabhag in mind when they decided this issue under the Mitakshara law. And why do I say this? See, as I said, there cannot be a partition unless the legislature has specifically said so that upon the death of a co-parcener, the whole co-parcenery will cease to exist. Now, just imagine if upon the death of one co-parcener, the whole co-parcenery ceases to exist, then the whole basis of a Mitakshara co-parcenery goes. That's why the Supreme Court was wrong, I believe. And later on, I have proved to be right, which I'll demonstrate uh, in a short while. Now, as all of us know, in 2005, a big change was brought about so far as Mitakshara coparcenery is concerned. And on the basis of Article 14 of the Constitution, in fact, daughters in a coparcenery were given equal rights to those of the sons of the family. Sons were already coparceners. Daughters were given equal rights in the coparcenery. Of course, with rights always go liabilities, so they also have now to share in the liability. So rights, liabilities, everything was given to the daughters. Now here, uh, before I go to the actual interpretation of that section, I would like to take you back again to what happened so far as the old section is concerned. And why is that? Because even while setting aside some judgments, the Supreme Court has also dealt with the old Section 6. And it has said the same thing that I have told you right now. What did the Supreme Court say here? Supreme Court said, so far as the old section is concerned, old Section 6 is concerned, that the statutory fiction is with respect to the extent of the share of the deceased co-parcener in the exigency that is provided under Section 6. And the coparcenery does not come to an end by statutory fiction. When the proviso to the unamended Section 6 of the Act came into operation and the share of the deceased coparcener was required to be ascertained, a deemed partition was assumed in the lifetime of the deceased immediately before his death, that is, on the date of his death. Such a concept of notional partition was only employed to work out and to give effect to the explanation under Section 6. That fiction was meant only for a specific purpose and it would never bring about an actual partition. So, in fact, the Supreme Court echoed the exact words, almost the exact words that I put in Mulla's Hindu law. And even without naming the judgment in Uttam versus Sobhag Singh, it is my belief that because this is a larger bench and because this is what the Supreme Court has said, so far as old Section 6 is concerned, Uttam versus Sobhag Singh is therefore impliedly overruled by the Supreme Court, even while not saying so specifically. So, Uttam versus Sobhag Singh interpretation is completely gone. The interpretation given by the Supreme Court itself in State versus Narayan Rao still holds the field now. And why does this help? What would in fact have happened if the new interpretation of the Supreme Court had held the field? It had already in fact started happening on practical aspect. If there are other professional amongst us, probably chartered accountants will be able to tell you, tax authorities had started saying that, oh, partition has taken place. Look at the judgment in Uttam, without understanding what the implications were. Thankfully, it has gone back to the interpretation in state of Maharashtra versus Narayan Rao now. So that is one big controversy that has also been put to an end by the Supreme Court. Now, if we actually go to the meat of today's talk, uh, after the new amended Section 6 came into force, what happened? And what was the section? If the initial words of the section are seen, it says that on and from the date that the amendment came into force, the daughter of a co-parcener would become a co-parcener with all the rights and liabilities of the co-parcenary. This section, in fact, came up for interpretation before various high courts, trial courts, of course, then high courts. Now, because high courts are courts of record and the judgments are reported, they hold the field. Uh, in one judgment of Vaishali Satish Gavnekar, the Bombay High Court gave a very unusual interpretation to the section. What did the Bombay High Court say? Simply put, it's a very long judgment, but very simply put, the Bombay High Court said that since the section comes into force on a particular date, only daughters born after this section are entitled to the rights under the section. Now, again, I had a chance to write about the section. I criticized that judgment very soundly in Mulla's Hindu law. Those interested can look at that commentary that I have stated there. Now, there was a further development here. A group of second appeals came up before a learned single judge of the Bombay High Court. He disagreed with the view taken in Vaishali's case. But since he was a single judge, he could obviously do nothing about it. So what did he do? He referred the matter to the learned Chief Justice, then presiding. The learned Chief Justice of the Bombay High Court formed a full bench. And in the full bench, the view taken earlier was reversed, that daughters born at any time become co-parceners. But again, the sad part here is the learned Chief Justice was himself actually a part of the division bench. He was heading the division bench in Vaishali's case. Fortunately, he was part of the full bench, and then the full bench, of course, did away with Vaishali's case and said that daughters, whenever they are born, will become coparceners. So that interpretation was also put to rest. Now, the provision has come in for interpretation, as I said before, various high courts, time and again. Quite a few of the high courts have taken the view that daughters whenever born, but then certain high courts took different views. Trial courts, of course, at this stage don't matter because, as I said, high courts are courts of record and their judgments are cited. So it's the high court view that ultimately matters so far as the state is concerned. Now, if we go further, uh, this issue as to when does a daughter become a co-parcener reached the Supreme Court. The judgment in question was Prakash versus Pulvati. And what did the Supreme Court hold there? The Supreme Court said that in Prakash versus Pulvati, that equal rights and everything is all right, but but the father co-parcener would have to be alive when the daughter claims her right after the amendment. And why did this happen? Again, see, law is of course and always a matter of interpretation. Why did this happen is the opening words of the section itself. The opening words say, on and from the date of the amendment, the daughter of a co-parcener are the words that are used. Now, because of the choice of words used by the legislature, the daughter of a co-parcener, the Supreme Court said that because these words are there, it must be held to mean that the father has to be alive as on the date of the amendment. Now, as I said earlier, what is one necessity for becoming a co-parcener? One and only necessity is birth into the co-parcenary. How are shares worked and reworked? Births, marriages, deaths, everything results into reworking of the shares in a co-parcenary. It is never dependent upon somebody being alive for anyone else to claim a right or a share. So to that extent, Prakash was also wrong. Interpreting the further provision that uh, partitions on and before 20th of December 2004 are protected, yes, the decision in Prakash versus Pulvati did say that, but so far as the right of a daughter is concerned, it was again wrong. Now, that held the field for some time, about a couple of years. Then in 2018, the Supreme Court again was seized of a similar matter. That is the case of Danamma versus Amar, which is in fact reported in 2018 three Supreme Court cases, page 343, if anybody wants the citation. There, of course, I very humbly say that they quoted a lot from Mullah's Hindu law, from what I had written. But ultimately, what did the Supreme Court say in Danamma versus Amar? They said that it is not necessary for the father to be alive. Daughter, any time that she is born, becomes a coparcener. They referred to Prakash versus Pulvati, took a different view, and also dealt with the issue of partitions. But the issue on partitions was again based on what was stated in Prakash versus Pulvati. So to that extent, they agreed in what was stated in Prakash versus Pulvati, that earlier partitions, because they are protected, nothing can be done about them. Now, law, as I said earlier, is always a matter of interpretation by courts. Words, intention of the legislature, everything counts. Very interesting matter again arose before the Delhi High Court, which ultimately reached the Supreme Court. That was the case of Vinita Sharma versus Raksheshsharma, where the Supreme Court in fact noticed the differences in Prakash and the uh, earlier decision, the later decision in Danamma. In these circumstances, what should happen? And what did happen was that the Supreme Court said that because of the differences here, we will now refer the matter to a larger bench. Now, that in itself, to my mind, is a rarity because very, very few matters in the country, in fact, are referred to larger benches so far as interpretation of family law is concerned. So, to that extent, also, this judgment is very important because, again, it is by a larger bench of three judges and will obviously hold the field now because, of course, the interpretation is now correct. Now, what did the Supreme Court do in Vinita Sharma versus Raksheshsharma? If I put it very simply, the Supreme Court righted everything. They said that any time that a daughter is born, she becomes a co-parcener. Two, it is not necessary for the father to be alive for the daughter to become a co-parcener. These are the two very important things that were said here. However, another important thing that the court said was also this, because if you see the section, the later part of the section says that uh, partitions or alienations which have taken place before the 20th of December 2004 are protected. That is one aspect. But the second part of the section says that how should a partition take place? The section said that partition must take place either by a registered deed or by decree of a court. So these are the only two modes in the way in which a partition can take place. Now, what did the Supreme Court do here? The Supreme Court said that even if a partition has taken place earlier, but if it does not meet with the rigor of the section here after our interpretation, then those partitions can obviously be reopened. And why is that? I have to explain this in a very practical way. Suppose, say, the brothers amongst themselves have decided that let us partition the property for whatever reasons they might have done it, either genuinely or maybe to keep out their sister. I don't know. But suppose they say that, okay, let us enter into a partition deed. They enter into a partition deed, divide the property amongst themselves and start enjoying it. Supreme Court said that no, this will not do because because the interpretation that we have given is retroactive. Even earlier partitions will have to be in consonance with this section. Therefore, earlier partitions can be reopened if they are not in consonance with the interpretation put by the Supreme Court in the judgment in Vinita Sharma's case. Of course, that is bound to open up quite a lot of partitions if they have not taken place in the proper manner. In the same way, say suppose partition deed has not been properly made, that also will now be open. A sister can go to court and say that they said that they have partitioned the property. However, look at it, look at the deed, it's not been done properly, it is not registered as per the section. Therefore, it cannot be done. Now, so far as partitions are concerned, another very important aspect, so far as Hindu law is concerned. For this, we have to also look at something from the Code of Civil Procedure. Now, as all of you might be aware, there are two decrees in a suit. A preliminary decree is passed and thereafter a final decree is passed. Now, as per the judgments, various judgments of the Supreme Court interpreting the code and the provisions as regards decrees, Supreme Court has said that a preliminary decree never brings about an end to a partition. It is only done when the final decree is passed. And this was in fact said in one judgment which traveled to the Supreme Court after the amendment, where the Supreme Court said that the sisters had in fact asked for their rights after the preliminary decree was passed. They sought to be made parties in the suit. Brothers obviously and of course claimed that there is already a preliminary decree, nothing can be done now. Supreme Court said nothing doing. In a partition suit, it is only the partition only happens on the passing of a final decree. So the daughters were made parties, and the whole of the shares were reworked, and the daughters were given their shares. So partition always takes place only when there is a final decree passed. Preliminary decree is nothing so far as partition suits are concerned. So that is the other interpretation also that was given by the Supreme Court. So very important issue has been decided by the Supreme Court. Now, if we go to the other aspects of women's rights here under the Hindu Succession Act, the other thing that was done is this. There was one section 23 in the Hindu Succession Act which said that suppose there is a house property and suppose the brothers decide to divide the house property amongst themselves, the sister can get a share only when the brothers decide to divide the property, not otherwise. That section has been done away with. Why? Because now the daughter is a co-parcener from the very beginning. She can ask for her rights because now that section itself is also gone. Next aspect that I'm dealing with, of course, does not deal with women's rights. It's just an interpretation of the provision. See, in Hindu law, we also have or had something that is known as pious obligation. What is pious obligation? That was that the son always had to take care of any legitimate debts that his father would have incurred during his lifetime. That doctrine of pious obligation is no longer there in Hindu law. That has been done away with. What is the reason behind this? We obviously cannot travel into the mind of the legislature, but this is the obvious reason, as I say. Now, it is not the pious obligation of the sons, and the sons therefore will not be personally liable for any debts of their father, but it will be the share that would have come to the father, suppose in a partition, that would be liable. So there is no personal liability on the sons so far as any pious obligation is concerned. There can also be another reason for this. If, as all of you know, and those of you who do not know can make a note of this. Say, suppose somebody goes to a bank for a loan. What happens is obviously the bank asks for a collateral security. Documents are signed. Documents of guarantee are signed. Now, because of all this happening legally, the doctrine of pious obligation obviously is put to the side because now there is a binding contract. Say, suppose the son himself is a guarantor. Then question of pious obligation does not arise. He has also entered into a contract with the bank in order to, say, pay up the father's debt. If the father doesn't pay it, or say, suppose the father dies, so the son guarantees it. So that doctrine of pious obligation is gone. That is another aspect that has happened so far as Hindu law is concerned. Now, in fact, while putting an end to the controversy, what has the Supreme Court ultimately held? This, of course, it's the later part of the judgment, so I will just try and read out those 5 or 6 lines to you. The reference in the matter was answered by the Supreme Court in this wise. They said that provisions contained in substituted section 6 of the Hindu Succession Act 1956 confer status of co-parcener on the daughter born before or after the amendment in the same manner as the son with the same rights and liabilities. That was the first thing that was held. Second was that the rights can be claimed by the daughter born earlier with effect from 9th of September 2005, regardless of the fact whether the father was alive or not. Again, it was also reiterated that the statutory fiction of partition created by the provisor to section 6 in the old section will not result into an actual partition or disruption of the coparcenary, and that the fiction was only for the purpose of ascertaining the share of the deceased co-partner when he was survived by a female heir. So this is what was held by the Supreme Court so far as this very important section is concerned. And of course, the last direction was because now one thing is clear. Now, whatever suits or appeals are pending, question whether the daughter is a co-partner or not, or from when she gets that right, is not important. The daughter is a co-partner, similar manner as the son. Only thing that now requires to be decided is as to whether any alienation of property, any partition, or any arrangement that the brothers have entered into is proper or not. So, what the Supreme Court has done, and rightly so, is they have given a period of 6 months to all the various courts to decide these issues. Put an end to everything in 6 months. Daughters are co-partners. Only thing that remains to be decided is this. So, huge and important thing has been decided. This controversy is really now at rest. Nothing more is required to be said here. Uh, Only thing that remains is now working out of shares, as I said. With that, of course, I bring to an end this short lecture, and I would open this up to questions from lawyer friends and students.
The first one is, as per the recent Supreme Court judgment, both
Mhm.
son and daughter have equal rights to inherit
Yes.
the ancestral property. However,
Yes.
what if the
Hmm.
partition is done only between the sons in 1999, depriving the
Hmm.
daughter's right, stating daughter is married before 1985 Act, hence no share. Now
Hmm.
the daughter is not alive. Can the legal
Hmm.
heirs of deceased daughter eligible to challenge the previous partition?
See, here two things are there. One is, of course, say if the partition had taken place validly. Suppose the partition has taken place, say, as you said, somewhere in 1985, 1990, but it has been done validly. It is a registered partition. Or suppose there has been a suit and there is a proper decree, final decree has also been passed. Then, of course, neither the daughter nor her heirs can do anything about it. However, if, say, the partition has not been done in a proper manner, as per the interpretation of the Supreme Court in the latest judgment, Vinita versus Rakesh, then the partition can be reopened. Because just because the daughter has married, she does not cease to be a co-partner in the father's family. There is no distinction made between married and unmarried daughters. So the partition can be reopened by her if it has not been done properly. As I said earlier, suppose the brothers have partitioned the property, but have not, say, got the partition registered, then it is no partition in the eye of law. The daughter can challenge that.
Okay, sir. Another question, which is also one of the most highly voted question, is if the father is no more and
Hmm.
partition already happened between brothers earlier,
Hmm.
with this amendment, when this amendment was not there, can
Hmm.
sister claim her share after this amendment? You've answered the question, sir, in your webinar, but could you just
Yes.
repeat it?
I think I've already answered it and I repeat it. If the partition has taken place earlier, nothing can be done. To repeat, if the partition was not proper, then it can be reopened, otherwise not. Say, suppose to quote a small example, suppose the partition has taken place somewhere in 1990. That partition is a registered partition. All the co-partners have taken their shares and gone away. Now, because at that point of time, this section had not come into force and the daughter was not treated as a co-partner then, she cannot do anything about it if the partition was valid.
So the sum and substance of were to be that if the partition is A registered, then
Yes,
nothing survives.
then nothing survives.
Okay, sir. One
Same
more.
thing, same thing with a decree. Suppose there is a preliminary decree and
Mhm.
final decree has not been passed, then the daughters will get a share. That a share of the daughter has to be worked into it, and then the shares have to be given out by the court.
Mhm. Another question is, if a Hindu daughter marries a Muslim man,
Hmm.
converts to Islam, will she still have a right on her father's property who has died intestate?
Daughter marrying into another religion, right?
Yes, sir. And converts to the other religion.
Conversion. Hmm.
Would she still have a right on her father's property, whether he dies intestate or leaving behind? Uh, uh,
Conversion is no longer a disqualification.
mhm. Okay, sir. So then it goes back to if there was a proper partition.
Yes.
Okay, sir.
Everything hinges on that. I'll
Okay.
take this a step further also. See, under Hindu law, there is also another way to do things. We have something which is known as family arrangements or family settlements.
Yes.
Suppose the family sits together and decides that let us do things in such a way that there are no future disputes. Let us divide the property in a certain manner. Say, suppose that has been done. At that point of time, this section was not there. Now, because that family settlement or arrangement deals with something that has to be done maybe in future, then immediately upon the coming into force of this section, daughters can claim that this arrangement that you have worked out has to be reworked because now we have rights because there is no actual partition.
Hmm.
They can ask for their shares under the new provision,
Okay, sir.
even in a family settlement.
Settlement. Okay. Um, how should a daughter distinguish between self-acquired property and ancestral property, where properties have been purchased in the names of a male member?
Right. A very practical question. You see, for that, obviously the source of funds is very important. And in India as elsewhere, of course, one who alleges must prove. Say, suppose a daughter says that this property is the self acquired property of my father and not family property, then she must prove it. If she says, on the other hand, that this particular property is co-parcenary property and it is not self acquired, again, she has to prove it. So, the source from where the funds for purchase or acquisition of that property are concerned assume importance, and she would have, or in fact, any co-partner who alleges that has to be proved, has to prove it. Yeah, so far as co-parcenery is concerned, of course, family nucleus, as they say, family nucleus is important. All that will have to be proved by the person alleging as to whether it is co-parcenery property or whether it is self-acquired property.
Got it.
Depends on, hinges on proof, absolutely.
And the source of funds, to trace back the source of funds to prove it.
Yes, yes,
Okay, sir.
absolutely.
Um, since daughter is a co-partner, then do her children, like children of male co-partners, become members of that HUF?
Sorry, members of,
If the so with this amendment, the daughter becomes a co-parcener.
what about her children? That is the
Yes.
question,
Yes.
right? Very interesting. In fact, I have answered this question somewhere in an article or maybe in a webinar. I don't know. See, one thing that is to be remembered is to become a co-partner has to be born into the family.
Yes.
Now, the sons of sons automatically become co-partners.
Yes.
But so far as the daughter is concerned, though the daughter remains a co-partner, her children will not become co-partners in her father's family. Why? One, complete bloodline changes, and they in fact would actually be co-partners in their father's co-parcenary. Whereas so far as the daughter is concerned, they would be treated only as her heirs and not as her co-partners.
Okay, the distinction is very clear because of the
Distinction is
marriage.
very clear in that sense.
Okay,
They are only treated as heirs because they do not belong to the family. They are not born into the family. That is why.
okay. If a Hindu widow whose share was determined in terms of old Section 6 after the death of Hindu coparcener, but who chose to remain in the family and her share remains undivided, whether her share will be reworked in view of daughters being given share.
Again, interesting question. Now, as I have said earlier also, and as in fact I have written, uh, the moment the statutory fiction under the old Section 6 comes into force, what happens is that the share of the widow is locked, I would say. I use the word locked. Suppose I put that in monetary terms. Suppose her share comes to 50 lakh rupees. That 50 lakh rupees is locked. There can be no decrease in it, even if she remains with the family. Whether it is increased or not, it cannot be increased also, but whether it increases or not will again depend upon how the family members think about it. Whether they want to increase her share or not. Say, suppose she says that, okay, I have got 50 lakh rupees as a share, but now I have decided to remain with the family, not claim my share, but the wealth of the family has increased. So my share is also to be reworked. Technically and legally, her share cannot be reworked. She has to be content with that.
Mhm. Okay.
But on the other hand, if she says that, okay, this 50 lakhs is there, I am not claiming anything, let it remain with the family, and if in future there is a partition, my share has to be worked out at that point of time, then it will all depend upon the agreement that the family reaches. I would say it's not part of the law, but part of a social consideration that can take place. Otherwise, her share is locked in on the date of her husband's death.
Okay. The next question is, if the brother has taken signature of sister on affidavit
Hmm.
that she is foregoing her right to her father's property,
Hmm.
can it be challenged and can her right be enforced? Father is no more and the affidavit had been signed by the sister while the father was alive.
Uh, One, was there any coercion when she signed it?
So normally there's always the father who gives the social pressure on the daughter.
I know. But again, you see, this is a very ticklish issue. Say, suppose the signature of the daughter has been obtained, that okay, I am giving up my rights. Let us put a time frame on this. Suppose such an affidavit has been signed by the sister somewhere in the year 2000, but this section comes into force in 2005. By that time, even as per her affidavit, nothing has been acted upon, say. Then probably she can claim a share. But on the other hand, if she says that I am giving up my rights, as they say, then what is the right given up? Is it in terms of actual property? Is it monetary? Again, all a matter of evidence. But normally, if it has not been done by coercion, etc., then she has to plead coercion. But if it has not been done by coercion, then she might lose her right, and validly so.
Okay, sir. What if the father has alienated the ancestral property in 1998,
Hmm.
dies in 2000? Can the daughter reclaim the property now in view of the latest judgment? I think you've just answered it, but if you can
No,
reiterate.
can't be done. Can't be done.
Is there a period of limitation to file a partition suit and also to set aside any alienation?
Normally 12 years after partition.
Okay.
Here again, you see, look at the interpretation of the Supreme Court. See, suppose, uh, as I said during my talk, suppose something has happened in 2000, say a partition or maybe a division by way of a deed has happened. But it has not happened as per this section because the section has been treated as retroactive by the Supreme Court. Then that period of limitation will probably not count. Suppose it has happened in 2000, but immediately after, say, this interpretation, because the time taken by the court to decide that has to work in favor of the parties.
Okay. So the next question is, can a daughter adjust her one-third share in the HUF flat to one-third share in the individual flat, both being connected flats of the deceased, and obtain two-thirds in one flat, being the individual flat of the deceased?
Again, this is very factual, will depend absolutely upon the agreement that she reaches with her brothers. This is factual rather than legal.
Yes, yes.
It all depends upon what kind of agreement that she arrives at with her brothers,
With her brother.
magnanimity of the brothers as well as the sister. Maybe somebody might have to give up something and rework the whole thing.
Yes. Um, if under partial partition her father had separated from HUF prior to amendment, then does she become co-parcener of the main or the larger HUF since it is retrospective? Does she form a new HUF with her father qua assets, which father received on partition?
No, you see one thing. Uh, I'll come to partial partition a bit later, but say suppose the father has separated, as you said,
Yes,
right? He
yes,
has taken away his share and gone away. The other co-partners remain in the co-parcenary.
yes,
Then with the amendment coming into force, she will probably be a co-partner, but in the old HUF, not so far as the property that her father received as a part of the partitioned assets, because after partition, whether it is partial or full, as per the interpretation of the Supreme Court in Chandar Sen's case, I believe, Commissioner of Wealth Tax versus Chandar Sen, that portion is that of the father alone. And if anybody claims after the death of the father, then it is only as an heir and not as a co-partner.
yes.
That is the first part. Now, so far as partial partition is concerned, good that somebody asked the question. See, in Hindu law, there are two kinds of partition. One is a full partition where the full property is partitioned, everyone goes away.
Mhm.
In partial partition, again, there are two kinds of partition. One is partial as to property, the second is partial as to person. One,
Ye-
partial as to property, meaning thereby, to go by example, suppose the coparcenary has 5 or 6 properties. The coparceners decide that in order to do something else, let us get rid of one of the properties. That property goes, it does not remain part of the coparcenary, so partial as to property. Partial as to person, one person from the coparcenary deciding to go away, as you quoted the example of the father.
Mhm.
Partial as to person, that person goes away, that person is no longer then a part of the coparcenary. But very important thing here, though Hindu law still recognizes the concept of partial partition, the Income Tax Act of India does not recognize partial partition. Section 171 of the Income Tax Act and the famous case of Apurva Shantilal.
Okay.
Partial partitions are no longer recognized. They have to be full partitions.
Mhm. So the next question is, if oral partition is done and it reflects in government documents, can daughter still challenge the partition?
Oral partitions have been done away with by this new section. The Supreme Court has also dealt with the very same issue in Vinita. I would urge the person who's asked the question to read Vinita's judgment. Oral partitions are no longer recognized. So even if it is recognized in government records, it would probably still be open to challenge that yes, a partition has taken place. But if actual partition by metes and bounds, because partition means a partition by metes and bounds, say suppose even if it is reflected in the government records, but if an actual partition by metes and bounds has not taken place, then the daughter can probably successfully challenge it.
Okay. So what about a daughter having any share in self-acquired property of her parents? Is that by will?
No, you see, two things. See, so far as self-acquired property is concerned, obviously, uh, a father or whoever is there can make a will of his self-acquired property. There can also be a will of co-parcenary property, in fact. I'll come to that. But even if the father dies intestate,
Mhm.
suppose he has self-acquired property, then that self-acquired property will go as per the provisions of Hindu law
Okay.
on intestacy. If there is a will, as per the will.
Okay. Um, what happens when a daughter wills her co-parcenary share to her children? Would the children get access to the share on partition of the HUF only, or can they claim and get access to the amount on demise of the mother?
Question. Very good question. Very good question. As I said earlier, see, the children of the daughter are not co-parceners
Yes.
because they are co-parceners in their own father's co-parcenery. However, because they are heirs of the daughter, say, suppose the daughter has made a will, she can obviously, because Section 30 of the Hindu Succession Act says that a Hindu can make a will of any property. That also includes co-parcenary property. So suppose she has willed away her portion of the co-parcenary property of her father, then the children can enforce a partition that please partition this. Our father has given, our mother has given us her share. They can enforce a partition. There has to be a general partition thereafter.
Okay. So what is the
But they
rationale?
are not co-partners, mind you.
Okay. Okay.
Sorry, what is the rationale?
What is the rationale behind the preliminary decree and the final decree as regards partition?
Yes. See, what happens is, why preliminary decree, why final decree? I would urge whoever has asked this question to look at those provisions under the Code of Civil Procedure. But you see, final rights, because upon an adjudication by the court finds that, okay, this is required to be done in a particular manner. This is our judgment. So, reflecting that judgment, a preliminary decree is passed. Thereafter, final decree follows thereafter after taking into consideration all the rights, liabilities, absolutely. And it is only after all the rights are worked out and after everything is done that a final decree takes place. That is the distinction. But I would urge the person asking the question to go to the Code of Civil Procedure for this.
Can a daughter claim partition in a property where the brothers are living separately, though there is no official partition, but since they're living separately, will they be considered as partition by metes and bounds?
Yes, of course, see, brothers might be living separately, etc. But if the property in question is co-parcenary property, then obviously the sister can claim that partition now.